The third way that people create problems for their heirs is by giving their property over time to multiple people, all right? So I have personal experience with this. A client of mine reached out to me and explained the situation that I'm going to lay out to you. I'm going to keep names out to protect the innocent. But they were advised by an estate planning attorney many years ago that what the parents should do, Mr. and Mrs. Z, let's call them, Mr. and Mrs. Z should give their property over time to their 5 children. Because back then, capital gains were different, and it made sense to gift a little bit every year to each of their 5 children. And they did that. Mr. and Mrs. Z passed away, but during their lifetime, they were able to give 75% of the property to their 5 children, which means each child owned 15% of the property. When they died, 25% of the property was still owned by their estate. All right? So right now, in the story, there are 6 owners of the property. All right? Mr. and Mrs. Z die, and shortly after they die, one of their children dies, which means that their grandchildren, 3 of them, inherited their one child's interest. All right? So now we have 8 owners of the property. Mr. and Mrs. Z's trust, the 4 living siblings, and then the 3 grandchildren. Now, this creates a lot of potential problems, and many of them have been realized in this scenario that I'm outlining for you. Let me walk through those potential problems. The 4 remaining children of Mr. and Mrs. Z's are supposed to inherit the remainder of the property. Okay, that's 25%. All right? And right now, the property is probably worth $850,000. But in order to distribute the money from that 25% remaining in the Aziz estate, the property needs to be sold. And in order to sell it, all 8 owners have to agree to the sale. The Aziz trust, the Aziz 4 children, and the grandchildren. And guess what? One of them doesn't want to sell. And now the property can't be sold. Okay? And the challenge with this setup is we need 100% agreement from 8 people. And I guarantee you there's not 8 people in the world that will agree on 100% of anything. All right? Secondly, the property is being rented. There's repairs that need to be made, but because the ownership interests are so diluted, nobody wants to put money into the property, and it's running down. And I see that time and time again, where too many people own a property and no one's responsible, then nothing gets done. Because it doesn't make sense for me to put money into the property if I only own a small fraction of it. By creating 8 different owners, we've just created a situation where no one's in charge and no one's responsible. Even though only the Z's children are supposed to inherit the remainder of the property, turns out the grandchildren want a part of it because their parent would have inherited it and given it to them. Does that make sense? And they logic or figured out or somehow came to the conclusion that just because mom and dad died doesn't mean that their part of the family shouldn't inherit their portion of the remaining part in the trust. This hasn't happened yet, but when another of the Z's children pass, that means that the ownership interest is going to get diluted further. The person that I know who's involved in this mess has 3 children of their own. So when they pass, that means that you're going to add 3 more people to the ownership title. And it becomes harder and harder as the Z's children die, because the ownership interests are getting more diluted and more people are getting involved. It gets harder to come to any sort of agreement. The only way to resolve disagreements on a sale is for one of the parties to sue the parties that don't want to sell. And that's called a partition sale. And my experience has been, whenever a family member sues another family member, there will be an outcome. A court will issue an order on what the outcome is supposed to be. But those family members don't spend Thanksgiving together anymore. It tears the family apart. This isn't a comprehensive list of potential issues, but I'm sure there are more. And here's the final one I could think of that I wanted to share with you. The Z's paid $5,000 for the property in 1950. Hard to believe in today's numbers, right? If the property is worth $850,000 today, because they had deeded the property while they were alive, they've just created the potential of a large capital gains tax due on each of the interests that they gave away while they were alive. And again, if they had just done it through their trust and gave it to their kids after they died, no capital gains taxes. But they were advised to do it this way, and they did. So now their kids and grandchildren have a mess on their hands that I don't think will ever be resolved until someone sues each other or sues one another. Moral of the story, if you're in this sort of situation and your parents are still alive, I highly, highly, highly recommend that you get legal advice and maybe look at a way of unwinding the damage that's been done before they die. It may or may not be able to be done, but it's certainly worth talking to a real estate attorney or an estate planning attorney to figure out how to get that done. And number 4, I see people appoint more than one person to settle their estate. They set up a co-trustee situation or a co-personal representative situation or a co-settler situation. And the problem with creating more than one person responsible for the estate, generally when more than one person is responsible, no one's responsible. Number 1, because I think you're doing it. And number 2, you think I'm doing it. But more importantly, and I'm going to need my notes for this, here are the potential general issues you create. Number 1, they're going to have to agree on any decision they make. If one doesn't agree, they can't make a decision. Number 2, if they can't agree, then one of them is going to have to sue the other if they want to have a decision made. All right? Number 3, many times older siblings, I mean, people can be 50, 60 years old, older siblings feel that they're the ones that should be making the decisions and choices. And that younger sibling isn't as good as them or isn't as smart as them because they're the younger sibling. So there's old biases that may be in place. Now, if one of your heirs is living in the property, they may not want to sell. So if your daughter's in the property and your son's not, the daughter doesn't want to sell. She's living there probably many times rent-free. And unless your son is willing to pick the fight, he'll never see any of the inheritance as long as your daughter's in the house. And then number 5, I think this is, the wild card in all of these scenarios are spouses. Your children may be perfectly normal, right? Perfect, they get along well, but if you put a spouse in there that has a bone to pick or feels like their spouse is getting the wrong side of the deal, they can be the sticky wicket and they could be the one that starts creating the problems, okay? So let me give you an actual scenario that I was involved in. There's a property up in Manoa. 3 sisters were appointed co-personal representatives. Daughter number 1 lived in the mainland. Daughter number 2 lived on Oahu. And daughter number 3 lived in the house in Manoa and had been living there with her family and spouse. Mom and dad pass, okay? And after they pass, daughter number 3, the one living in the house, wants to buy out the other sisters, which they're happy to sell their interest. And she offers the sisters a value of $600,000 on the property, which means that each sister's interest is worth $200,000. Now, the middle sister, the peacemaker I call her, who lives on Oahu, decides to take the $200,000. But the sister that lives in the mainland doesn't want to take the $200,000. She believes that the property is worth more than what the third sister estimated it at. In fact, when I was brought into the transaction, I thought the property was worth $800,000. All right? So sister number 1 and sister number 3 decide to try to resolve things. They attorney up. Never good when people attorney up. But they get attorneys. They try to negotiate a solution. And it turns out they can't. So sister number 1 sues sister number 3 via partition sale. All right? So that's when I'm brought in to the transaction. They need a partition commissioner that's appointed by the court. I'm brought in. I do the marketing so that we can get to the court steps to auction the property. We get on the court steps. Other people show up. Ultimately, it comes down to sister number 1 and sister number 3 bidding on the property. Sister number 1 keeps bidding until the price gets up to $850,000. Are you with me so far? She bows out there. Sister number 3 agrees to pay the $850,000. And while we're walking away from the court steps, I'll never forget this, sister number 3 looks at sister number 1 and says, "The house is mine now, and you don't ever get to come over again." Can you see the problem the parents created? But sister number 1 ended up getting $83,000 more, and my honest opinion is that the sister living in the house was trying to take advantage of the sisters at a low value if you're supposed to pay fair market value. And I never ever found out what happened, but if you were sister number 2 and you took $200,000 and you found out sister number 1 got $83,000 more, how are you going to feel in that relationship with your third sister? Let's talk about how mom and dad might have set up things in their estate so that you could have avoided this outcome. And, creating disharmony in the family, hiring attorneys, absorbing all the costs of the attorneys, but most importantly, the disharmony in the family. First and foremost, in my opinion, they should have appointed one sister or one person or one fiduciary to manage the estate. That way, there's someone that can make the hard decisions. Given people's personal interests and motivations, it's just not realistic that 2 people are going to agree, let alone 3. And here's what I've noticed. Once mom and dad are gone, everybody plays nice until then. But once they're gone, the gloves come off and old scores are settled. All right? By the way, I found out later from sister number 2 that the 2 sisters that ended up bidding on the property, they hadn't liked each other since their teens. And in their 50s, which is about their age when we started this, plus or minus some, they were still settling scores from their teen years. Now, for better or for worse, appointing one person to administer it allows one person to make all of the hard choices, and the power is focused in that one person. Now, think about this. Had they appointed daughter number 3 to administer the estate, that property would still be owned by the 3 sisters, and it wouldn't have been settled Sister number 2 wouldn't have gotten her $200,000. Sister number 3 would never see any money, and it would be a mess. Another option, by the way, for the parents would have been to appoint someone else, totally unrelated to the family, or a family member that might be a business person, but don't appoint the sisters. Now, I believe in some instances it makes sense to appoint a professional fiduciary, and they're out there, and for management fees, they will settle the estates. They have designations that allow them to understand how to manage estates, and they have attorneys and CPAs and all the tools you need to take care of an estate. But that would have been a great solution. As I mentioned, you need that third party, because at the end of the day, once someone has to be the bad guy, you create this situation where there are going to be bad feelings. Once daughter number 3 is told, you can't live there anymore, we have to take care of the other 2 sisters too, if it's a sister doing that, it's going to be war. So think about all of these things, because while you're alive, you love your family, you have an obligation, in my opinion, to make sure that you don't leave people a mess. Put together an estate plan if you own real estate. I'm aware of a situation just recently, a client of mine. Boyfriend and girlfriend buy a house together, and they're in their early 30s, and there was no estate plan, and girlfriend dies in a tragic accident. Now we've got a problem. So if you own real estate, get an estate plan. Reach out to your friends, reach out to your relatives, ask for who is a great attorney or an estate planner that they like. If you can't find someone, call me, and I'd love to talk to you about it, or I can send you to any number of great estate planners that I know that will take great care of you. And if you just want to talk, call me, 808-398-3220, and I'd be happy to chat with you.